Student scholars, prior to beginning the substance of this videotaped lecture, I am sharing with you a statement about my philosophy of teaching that you will find consistent with the document you have received on guidelines for the community of learning for courses taught by Professor McNeil. I am using uploaded lectures as an alternative to interactive lecture and discussion in class when time does not permit our use of the lecture and discussion format in class. This may be occasioned by adverse weather conditions, eliminating class periods, or the alternative use of scheduled class periods. My statement will be the same before each lecture, so if you have already heard the statement about teaching philosophy once, you may feel free to fast forward to the beginning of the substance of the lecture itself on a particular designated theme. This lecture will be on the population of non-whites who are also non-African Americans, and I'm going to focus this time on Native Americans and on Asians and Asian from one or two generations of immigrants. Thereafter, we will, of course, as you know, in our textbook, be dealing with Korematsu, the case Korematsu, but I wanted to give you some opportunity to know how race has been constructed in relationship to Asians in the United States. Teaching philosophy. I lecture and have done so successfully, but it is my preference to emphasize participatory teaching. While I admire those professors and teachers who are eloquent lecturers and reach hundreds at one time and thereby impart such knowledge, I rarely deliver a lecture for a class without raising several questions I considered non-rhetorical, actual questions that require some thought and response. As a Brazilian educator, activist, and author of Education for Critical Consciousness and Pedagogy of the Oppressed, Paulo Freire, I am persuaded that students and teachers are always engaged in reciprocal process of learning, and that education plays a critical role in social transformation. For many years of my teaching career since 1987, I have chosen to make an intentional, conscious effort to reframe and restructure my courses in accordance with the principle of reciprocal and collaborative learning. I, as any teacher, have pedagogical goals for my classes. One set of goals has to do with process or procedure and methods of teaching and learning. Another set with substance. I know that there are elements of knowledge and information that each student scholar who enters a particular course of study ought to learn, know, understand, and retain long after leaving the course. It is because of the latter obligation that I have decided to provide these opportunities to hear a lecture and then respond to the questions in class when we have again gathered together during class time for discussion. Please remember that the recorded lecture is offered as a vehicle for communication of not only salient facts and concepts that will better prepare you for examinations on which you test yourself, but also for the subject matter that should give rise to questions, inspire more thought, provoke discussion that I hope will include critical analysis, creative thinking, and considerations of implications and consequences. I encourage you to participate in chat rooms as you see fit, but they are not a substitute for our class discussions and questions and critical commentary. Please do take notes and let me know both that which you need clarified or better explained, and that upon which we need to expand, or with which comparisons in history or the present need to be made. Finally, in the classroom, we have guidelines for the community of learning that include the advice of New York poet Jane Cortez. Find your own voice and use it. Use your own voice and find it. I urge each of you whom I consider to be both a student scholar and a history maker to understand at the deepest level that your contribution is unique and not 1 minute of your time is dress rehearsal. Thank you for your attention to the recorded lecture. I look forward to our post-lecture discussions in class. Racism and other non-whites. Other minorities who are identifiably non-white, Indians or Native Americans, Chinese, Japanese, Mexican, and other non-white Spanish and French-speaking people, has suffered exploitation and discrimination in ways quite similar to those experienced by blacks, and often for similar purposes. America, that is the United States of America, has exported racism to foreign territories that have come under its control, including the Philippines, Hawaii, which is now a state, of course, Puerto Rico, Cuba, and the Dominican Republic. Color as the basis of racist policy is not limited to the United States and its white supremacy and greed. Nonetheless, as we focus on the United States, in connection with considering other non-whites, what we will examine is essentially the social construction of race, the legal construction of race, and we haven't time to cover all the groups in the United States, but I can provide critically important information in this lecture about Native Americans and share some stories and cases that demonstrate clearly the construction of whiteness with all of its presumptions of superiority and worth as they have to do with persons of Asian descent. Definition of race. It is now settled scholarship that race is a social construction. The definition we use in this class and that you will find in your resources is one from Robert Miles, a book entitled Racism. Race is a social construction and social phenomenon affecting the identity and lived experiences of individuals, families, and communities, while also penetrating state institutions and market relationships, functioning as a fundamental axis of social organization in the United States. Although discredited scientifically as biological difference, race continues to be employed as a means of categorizing people and theorizing the social facts of color. Racism. Racism is the assignment of negative value to traits commonly associated with a disfavored race of people and the subordinate ranking of that race on the social hierarchy. The best definition of racism is an operational one. This means it is based upon the way people actually behave. Racism may be understood as any attitude, action, or institutional structure which subordinates a person or group because of his or her color. Even though race and color refer to two different kinds of human characteristics in the United States, it is usually the visibility of skin color and other physical traits associated with particular colors or groups that mark individuals as targets for subordination by members of the white majority. Overt racism is the use of color per se, or the visible characteristics related to color, as a subordinating factor. Among my sources for this lecture are Lawrence Freedman's essay, What is a Legal System?, Derek Bell's textbook, Race, Racism, and American Law, Annette Gordon Reed's monograph, Race on Trial, and Ian Haney Lopez's study entitled White by Law. As you know from Lawrence Freedman, law has four functions: social control, social maintenance, social engineering, and of course mediation and problem solving are at the micro and the macro level, dispute settlement or conflict resolution. By virtue of this, it is possible to have a practical existential understanding of law as socially constructed with respect to its elements: structure, substance, legal culture, and impact. Yet something that is not only acted upon, but also actively engaged in defining and shaping our society is, in fact, law. The legal construction of race, according to Ian Haney Lopez. Law is one of the most powerful mechanisms by which any society creates, defines, and regulates itself. Unquote. There's a particular way the law was manipulated and used in relation to the indigenous population of British North America and subsequently the United States. It is fitting that we discuss non-whites and begin with Native Americans, as they were here on this continent and immigrants from Europe and Great Britain came in as settler colonies where Native Americans were already living. Thereafter, I will move on to persons from Asia and Syria, and I have chosen to cover Hispanics or Latinas in the lecture that will address the Rodriguez case for time purposes. We are going to be discussing Korematsu as we deal with one of the chapters that focuses on World War II and civil liberties. So I will, in dealing with Asians, take you up to a point where you will be able to see a pattern of sorts and see that through the stories and the cases that Ian Haney Lopez calls prerequisite cases. We have just finished the New Deal, as you know, and you also know from reading that in law, what particularly changed at the time of the New Deal was that policy of trying to force Native Americans to assimilate and forget their tribal origins and language became no longer acceptable, and there was an Indian Reorganization Act during the New Deal. What we must understand about Native American policy and law is essentially what we have learned from the manner in which cases and policy have been handled in the past. Based on separative premise, when it was possible to move Indians to other territories, that was one way, separating the Native Americans, and assimilative, when it was not possible to move all of the Native Americans into another area, and of course, when Native Americans could easily be dispossessed by such devices as inflated tax appraisals and long-term leases returning minimal rents. Our policy in the United States also took advantage of Native Americans. You are aware, of course, that, before I go to that, I found a quotation from Chief Joseph that I want to share with you. Chief Joseph summarized the policy as one of the last great leaders of the Native Americans who was resisting the United States. And he said, quote, "The white men made us many promises. They only kept one. They said they would take our land, and they took it." Close quote. There was initially, in the 18th century, a treaty era when Native Americans and tribal groupings were recognized as sovereign, separate entities. Then there came a time when the settlers were seeking to expand, and states were seeking to move Native Americans out of their boundaries, that the case of Worcester versus Georgia came to the attention of the Supreme Court. John Marshall upheld the supremacy of federal over state power regarding Indian tribes, an issue that threatened to split the nation apart at that time, but which was never seriously considered as a focus for real division. The state of Georgia was told that the Indian tribes, and they used the term Indian, were sovereign nations whose rights of self-government predated the Constitution and whose dealings with the United States were governed by principles of international as well as constitutional law. Although the court in Worcester recognized that Indian tribes possessed inherent sovereignty rights, the decision was really a defense of the power of the federal government over the state government. You will, of course, also remember in 19th century history that there was the famous Cherokee removal, and after the Cherokee nations were forced to move, and there came about a time when there were additional cases and treaties, but the court analogized Indian nations to foreign nations in finding congressional power to deal with them in the 1830s continuously. The case of Cherokee Nation versus Georgia is an important case in that the court held that Indian nations were not foreign entities for the purpose of invoking the Supreme Court, but rather that the Native American nations should be considered domestic dependent nations, and that they were incapable of conducting their own affairs in relationship to the United States, and therefore were now to be understood in a position that was more or less resembling that of a ward, or the United States was the guardian for Native Americans. These domestic subjects then were akin to alien state citizens, but Congress granted them citizenship many, many years later. In the latter part of the 19th century, we find the end of treaty making and the end of any recognition that you have a sovereign nation or even a domestic dependent nation. With the attempt to continue to move west, we find that in the 1870s, the United States determined that it would end all recognition of treaties, and that it would instead talk about an allocation or allotment of land for Indians that were willing to move and become citizens of the United States as individuals. So heads of households were offered land in the West if they were to reject the system of living in their tribal organizations. The extra land that was left over then from what was given to Native Americans was made available to other white settlers in particular. The assimilationist policy also included boarding schools in which they placed Native Americans who were seeking to learn English and learn different trades to fit into the more modern industrial society, and they frequently separated them from those who spoke the same native or indigenous language so that they would be forced to speak English only. The most famous of the boarding schools was one in which the former Olympic champion Jim Thorpe was kept and was educated, and he was in the Carlisle Indian School. It was essentially forced acculturation, and the research of Dr. Pearl Lee Walker McNeil demonstrates the manner in which the forced acculturation and rules and regulations of the boarding schools required that Jim Thorpe play with a particular baseball league during the summer and be paid for that work. That then became the reason that he was stripped of his Olympic medals. But through Dr. Walker McNeil's research, because it was learned that he had no choice with respect to receiving pay for playing baseball, his family was able to receive the medals again. Citizenship for Native Americans, other than those who would be willing to come in as individuals and assimilate in the United States, essentially came in 1924 through a statute. Remember, however, that although state disenfranchisement of Indians continued into the 20th century, Indians as individuals could enjoy constitutional rights as other Americans, and attempts to assert constitutional protection for these rights, however, were largely ignored. I want to give one example, and then I'm going to need to move quickly on to Asians. The Mashpee Native Americans who live in the area of Cape and in Massachusetts had a case that they brought forward in 1976. The alienated tribal lands, using the Indian Non-Intercourse Act, would be the way in which Mashpee Indians sought to recover their land, the land that is a part of the Cape Cod community. They filed suit under the Indian Non-Intercourse Act. The district court ruled that in order to proceed, the Mashpee first had to prove that they were a tribe within the meaning of the word as defined by the Supreme Court in 1901, to wit, a body of Indians of the same or similar race united in a community under one leadership or government and inhabiting a particular, though sometimes ill-defined, territory. The Mashpee, seeking in 1976 to use the 1790 law of the Indian Non-Intercourse Act, were now being told that although they were original Americans, original Native Americans, that they would need to use a definition of their Native Americanness that was written by a non-Native American for a Supreme Court decision in 1901 in order to establish that they were, in fact, a tribal grouping of Native Americans. And of course, you can see the absurdity of that. So, once again, we see law defining and law shaping and law sometimes reflecting particular discrimination with respect to the way in which non-whites function in the United States. There is cognitive significance of legal categories of race. And we see that the legal category, for example, in the Mashpee case, was one that made it impossible for them to recover land that was in fact stolen from them. Law legitimates the existence of races, both in the weak sense of lending high-profile institutional support to the notion that races are biologically real, and in the strong sense that the legal recognition of races entrenches the belief that racial categorization is a necessary part of human differentiation. You will note later on that whenever we look at anti-discrimination law, it in fact depends upon the law making categorizations of race. Legal rules and decisions construct races through legitimation, affirming the categories and images of popular racial beliefs and making it nearly impossible to imagine a non-racialized way of thinking about identity, belonging, and difference. And again, this is underscored by the way in which non-discrimination laws are written. One must accept as a concrete reality the validity of race as constructed in the past in order to be able to seek any remedies for racism. Mary Frances Berry, who is the author of not only the book I mentioned to you earlier in our semester, Stability, Continuity, and Security, discussion of Harold Hitz Burton, the Supreme Court Justice who left his notes to the Library of Congress. And she's also the author of Black Resistance, White Law, spoke in a way that I think is very helpful as we think about moving into a discussion of persons of Asian or Syrian descent and the United States and law. Mary Frances Berry has explained, and I quote, "In reality, we are not two separate nations, one black and one white. Instead, we are three, one black, one white, and one in which people strive to be something other than black to avoid the sting of white supremacy. Racism against African Americans remains the prototype for racism in the United States of America. African Americans are the negative other against which all immigrant groups have tried to confirm their whiteness." It follows then logically that legal institutions and practices are essential components of our highly structured, litigious society. And I want to begin our discussion of Asian Americans, or excuse me, Asians in the United States of America, because the Asian American aspect is highly contested initially, and provide these stories so that you will have a sense of the way in which identity was indeed determined by three things, or one of three things, or two of three things in relationship to the law. Uh, Judges might make decisions based on what they consider to be the scientific or social scientific scholarship. They might make decisions based on a legal precedent having to do with a particular non-white group, and they might make decisions based on what they would end up calling common knowledge. Ian Haney Lopez has prepared for us in his book, White by Law, a list of prerequisite cases. They are cases that help us to understand the changing definitions of white and non-white in the United States through decisions made in the law. I have placed on Sakai and in your resources the chart with some of the cases that I will be speaking of today. There are essentially three cases that I would like to bring to your attention, and they are three very interesting stories. The first one is in 1878, and the case is Ahyup, A-H-Y-U-P. And as I indicated, you'll find that in your resource materials. In Ahyup, the 1878 case, we find that Yop is a native and citizen of the Empire of China, I'm quoting from the judge, of the Mongolian race, and that he has presented a petition in writing praying that he be permitted to make proof of the facts alleged, and upon satisfactory proof being made and his taking the oath required in such cases, he be admitted as a citizen of the United States, unquote. This was the first application of a native from China for naturalization. The members of the bar were requested by the court to make suggestions as amici curiae, that is, friends of the court, and in some of those instances, they provided a variety of responses. The issue they were asked to address in an amicus curiae brief was, is a person of the Mongolian race a white person within the meaning of the statute? The words of the statute, taken in a strict literal sense, constituted a very indefinite description of a class of persons. Obviously, we know that there are literally no persons who are completely white, that is, as white, the color. But white may be found in various shades. The words in the United States have, however, come to a settled meaning, that is, when we speak of the white race. And a white person, or a member of the white race in the United States, by 1878, they indicate is very clear, means a person of the Caucasian race. The social scientific knowledge at this time, 1878, was referred to by the judge. He talked about various classifications and depended upon those classifications, which were found in a dictionary, and relied upon the research of a scholar whose last name was Blumenbach. There are, according to Blumenbach, 5 races. 1, the Caucasians, or the white race, to which belong the greater part of the European nations and those of Western Asia. 2, the Mongolians, or the yellow race, occupying China, Japan, etc. 3, the Ethiopian or Negro or black race, occupying all Africa except the north. 4, the American or red race, containing the Indians of North and South America. And 5, the Malay or brown race, occupying the islands of the Indian archipelago. Neither in popular language, in literature, or in scientific nomenclature do we ordinarily, if ever, find the word white person used in a sense so comprehensive, the judge said, as to include an individual of the Mongolian race. In fact, and I'm quoting again, I am not aware that the term white person as used can be one that would include Mongolians. Quote, while I find nothing in the history of the country, in common or scientific usage, or in legislative proceedings to indicate that Congress intended to include in the term white person any other than an individual of Caucasian race, I do find much in the proceedings of the Congress to show that it was universally understood in that body in its recent legislation that it excluded Mongolians. At the time of the amendment of the Naturalization Act, and the Naturalization Act, as you know, in the 1790s indicated that only a white person may become a naturalized citizen of the United States. But after the Civil War, there was a need to modify, and so at that time, extended naturalization laws to the African race, making it thus possible for those who had been enslaved and had freed themselves or had been set free to become citizens. Charles Sumner made repeated and strenuous efforts to strike the word white from the naturalization laws altogether. But he was defeated in every instance, and in many instances, as one looks at the debates, it becomes clear that he was opposed because there had already been a large number of immigrants from China, and those immigrants were considered to be not at the level that they should be assimilated or naturalized citizens. That effort of Charles Sumner was defeated, and the amendment cited extending the right of naturalization then to Africans only, and it was adopted from those proceedings of Congress in the 1870s. So the word white that had originally occurred in naturalization acts from the 18th century continued in the 19th century to include the term white. and it appears from reading the materials and the debates that the purpose was to exclude Chinese from the right of naturalization. The court decided that whatever construction might otherwise have been given to the term white person, it is entirely clear that Congress intended by this legislation to exclude Mongolians from the right of naturalization. I'm quoting again, "I am therefore," the judge says, "of the opinion that a native of China of the Mongolian race is not a white person within the meaning of the Act of Congress." That is, again, in regard to Ayup, AHYUP, 1878. The second case is that of a first-generation immigrant from Japan who filed two different cases in an effort to become a citizen of the United States. Takushi Yamashita, Takuyamashita, was born in 1874 in Japan. As an Issei, Issei, a first-generation immigrant from Japan, then immigrating to the United States, he fought for opportunities to become educated at a post-secondary level. And in fact, he proved to be quite an extraordinary student. Once you hear some of his arguments, you will know why the legal scholar Gabriel Chin, that's C-H-I-N, called him one of the great Asian American lawyers of his generation. Chin writes as follows: "Attorney Takushi Yamashita did not earn a dime practicing law, never won a single case, and while he finished law school, could not even manage to get admitted to the bar. Unable to join the legal profession, Yamashita, like many of his fellow immigrants, lived a humble and anonymous life as a restaurant worker, a farmer, and housekeeper. Yet his 20-year legal fight to gain recognition as a citizen of the United States made him one of the great Asian American lawyers of his generation." Yamashita went to school in Tacoma, Washington after his parents immigrated to the United States. Because of his intellect and his ability, he was accepted into the University of Washington Law School. It had instituted a law school in 1902. He was one of 10 graduates in the second class of the law school. After he passed the bar exam, he filed naturalization papers because the state required lawyers to be American citizens. The state did not allow him to practice law, claiming that he could not become a citizen because of his race. And in response to this, he filed a brief with the Washington Supreme Court, arguing, among other things, that the state accepted lawyers who had passed the bar in other states that did not have a citizenship requirement, and also challenging the 1790 naturalization law that limited naturalization rights to free white persons. On October 22nd in 1902, the court ruled unanimously against Yamashita. Yamashita probably thought that he was protected by the naturalization papers that he had received, a certificate, when he came with his parents to the United States. Although a Washington statute, that is Washington state statute, limited admission to the bar to U.S. citizens, he had a judgment stating that he was a citizen based on this certificate. But there was a problem. Yamashita faced one of the oldest racially discriminatory provisions of the laws of the United States. Again, what was faced by Ayop. The 1790 law permitted naturalization only of an alien who was a free white person. And of course, as you know, after the Civil War, this was modified to include persons of African descent. As a person of Japanese ancestry, Yamashita clearly was not of African ancestry and certainly made no attempt to seek to be associated with Negroes. But he did acknowledge that he had all the requisite requirements to be admitted to the bar and to practice law, with the exception of his Japanese birth and heritage. The brief that he presented to the court is a very interesting brief of legal analysis, especially for lawyers just starting out. Yamashita drew on legislative history and case law and even appealed to, quote, the spirit which pervades the Constitution in support of a series of interesting technical arguments. First, he observed that Washington admitted lawyers from other states without the necessity of a bar exam or citizenship requirement, as we have mentioned before. Then he argued the proposition that all applicants for admission to the bar in this state must be citizens of the United States becomes absurd. He made the reasonable claim that when Congress limited naturalization to, quote, free white persons in 1790, it could not have specifically intended to exclude Asians, for at the time there was not a Chinese or Japanese person on the continent. He also made a point that seems to have eluded many modern scholars, but one that he made as a result of his studies in anthropology. This is that particular argument. When Congress allowed natives of Africa or those of African descent to naturalize, it extended the privilege in principle to Asians, stating that, I quote from the amendment, any person born in Africa, no matter what his color or race, whether Indian, Negro, or Chinaman, is capable of becoming a citizen of this country, since any such person is an alien of African ancestry. And of course, he was referring to the original home of the human race, Homo sapiens, being on the continent of Africa. He then went into a patriotic argument that included these words: the applicant desires to express the hope that this court will not take the position that members of a race which has shown itself in a brief period of years capable of taking its place in the front rank among the most highly civilized and enlightened nations of the world, as has the Japanese, are not fitted to become citizens of this, the most enlightened and liberty-loving nation of the world. The fundamental principles of freedom and equality are a part of the United States. And I quote again, a government and institution made possible by the blood of men who consecrated their lives to the establishment of a country in which all men are equal in rights and opportunities. The Attorney General of Washington State, who was arguing against Yamashita, dismissed his argument, mocking, quote, the worn-out Star-Spangled Banner orations based on the Declaration of Independence, all men are created equal. Of course, that was not something that needed to be recognized in this court. Yamashita responded with, your applicant has no apologies to make for his so-called worn-out Star-Spangled Banner argument. In one respect, Yamashita's brief fell short in an entirely modern analysis, in the sense that he was arguing that surely Japanese are not to be denied from mere accident of birth and without regard to fitness the right to become citizens of the United States because they were Asian and associated with, and this is his language, an ignorant and servile class of coolies. That is, he was trying to distinguish himself as an Asian from the Chinese, who, of course, were the object of an earlier Exclusion Act and considered non-assimilable. Alternately, it could be understood as accepting also a stereotypical view of the Chinese, but also Yamashita was citing Plessy versus Ferguson when he went on to say that discrimination against him should not be upheld by the courts. As we indicated before, nonetheless, the court in 1902 simply said, Yamashita, you are Japanese, and Japanese cannot be white people, therefore you cannot become a citizen. After that failed effort to gain admission to the bar by virtue of seeking to become a citizen, he decided that he would use another approach. World War I brought a set of ironies to residents of Tacoma's Japantown, as well as Asian American communities elsewhere. And there had been increased discrimination, exploitation, bigotry in relationship to Japanese. In fact, Woodrow Wilson, the same Woodrow Wilson that decided he would bring segregation to the federal government, in Paris at the conference establishing the League of Nations, made the following comment. I stand for the national policy of exclusion. We cannot make a homogeneous population out of a people who do not blend with the Caucasian race. Oriental coolism will give us another race problem to solve, and surely we have had our lesson. In 1921, the Japanese question was raised again following the war, and once again in Washington State, they not only upheld that Japanese were an inferior group along with the Chinese, but they passed a law, that law of June 9th, 1921, that said aliens ineligible for citizenship became ineligible to purchase lease, or inherit land. The law applied primarily to Asians because aliens of most other races were not in that particular area. This was a very harsh measure, but Takushi Yamashita demonstrated a second time that he was a formidable opponent and legal strategist. The direct constitutional challenges to the alien land law had failed. So Yamashita devised another approach, and in devising another approach to defeat the alien land law, he was able to come up with quite an ingenious idea for getting around the law. Yamashita started a land company, the Japanese Real Estate Holding Company, that would own the land. When the Secretary of State refused to accept the Articles of Incorporation, he once again turned to the courts. This time he did not represent himself. He was represented by George W. Wickersham, a former Attorney General under William Howard Taft. The case eventually went to the U.S. Supreme Court in 1922. The U.S. Supreme Court in 1922. In a landmark case, Ozawa versus the United States, had definitively designated that Issei, that is the first generation Japanese coming to the United States, were ineligible for naturalization. Therefore, in a later case, the same year, 1922, Yamashita's appeal was also denied. The court ruled against Yamashita and his eligibility for citizenship. He grew strawberries in Silverdale, Washington State, evading the land law by being a manager hired by a sympathetic white landowner. Then, to add insult to injury, during World War II, Yamashita and his wife were forcibly removed along with all other West Coast Japanese Americans. The Yamashitas first went to the Pinedale Assembly Center and next to Tule Lake, and then later to Minidoka. Unable to keep up payments on their land, being in the assembly centers or the relocation camps, the Yamashitas obviously lost their farm. Upon returning to Seattle after World War II, he lived with a daughter and worked as a housekeeper. He and his wife returned to Japan in 1957, where he died 2 years later at the age of 84. If you're interested in reading the wonderful essay by Gabriel Chen on Takushi Yamashita's struggle for citizenship, please go to Annette Gordon Reed's Race on Trial, Law and Justice in American History. And you may also be interested in the source in the newspaper, Rebecca Cook, Justice for Scholar Comes a Century Later, in which there is discussion of how a professor at the University of Washington uncovers this story of Yamashita and seeks to have him instated as a lawyer. The third case is one of a Syrian who has applied for naturalized citizenship in the Northern District of Georgia in 1909. This case can best be understood if I simply share with you the opinion of the district judge for the Northern District of Georgia in 1909. Listen carefully as he, again, as a judge, constructs race. In admitting to naturalization, the petitioner, Costa George Najour, it's Najour, and once again, he is listed in your documents and your resources. I wish to say this. Although the term free white person is used in the statutes, this expression, I think, refers to race rather than to color. Excuse me, I have had difficulty because of doing this lecture at a time when I was having some throat problems, but I am back to our case of Costa George Najour. And what I simply want to do for this third case of a person of Syrian ancestry and descent who has immigrated is read from the district judge's opinion in the case and demonstrate as another prerequisite case discovered by Ian Haney Lopez, the legal construction of race. Newman, the district judge, says, although the term free white person is used in the statutes, this expression, I think, refers to race rather than to color, and fair or dark complexion should not be allowed to control, provided the person seeking naturalization comes within the classification of the white or Caucasian race. And I consider Syrians as belonging to what we recognize and what the world recognizes as the white race. The applicant comes from Mount Lebanon near Beirut. He is not particularly dark and has none of the characteristics or appearances of the Mongolian race, but, so far as I can see and judge, has the appearance and characteristics of the Caucasian race. Quite a little while ago, there had been some additional research done, and again from the social science research of this 20th century era, we find the district judge referring to a study which he believes to give scientific support for his position. A study entitled The World's People by Dr. A.H. Keane, Keane, classifies without question or qualification in any way Syrians as a part of the Caucasian or white race, and this they are, so far as my knowledge and information goes. Dr. Keane divides the world's people into 4 classes: the Negro or black in the Sudan, South Africa, and Oceania, and Australia. Second, the Mongol or yellow in Central, North, and East Asia. The Amarans or red or brown in the New World, and Caucasians, white and also dark, in North Africa, Europe, India, Iran, Western Asia, and Polynesia. Close quote. Discussing these various nationalities and subdivisions of these four general divisions, the Negro or the Black in Sudan, and the other three, we find that unhesitatingly the scholar places the Syrians in the Caucasian or white division. The Assistant United States Attorney representing the government, objecting to the naturalization of Niger, seems to attach some importance to the fact that the applicant was born within the dominion of Turkey and was heretofore a subject of the Sultan of Turkey. I do not think this should cut any figure in the matter. If it did, the extension of the Turkish Empire over the people, unquestionably of the white race, would deprive them of the privilege of naturalization. Newman concluded, in my opinion, the applicant belongs to the white race within the meaning of the statute and the other requisites existing. After careful examination, he is clearly entitled to naturalization. In conclusion, let me share with you the insights of Ian Haney Lopez from his study on the legal construction of race. These prerequisite cases constitute a relatively unique body of decisions insofar as the judges there directly and self-consciously practiced racial categorization. The prerequisite cases demonstrate the multiple levels on which legal rules and actors construct the social systems of meaning we commonly refer to as race. Law is constructing race. The single greatest difference between what we might term the pre- and the post-Brown versus Board of Education jurisprudence era is that, generally speaking, since Brown versus Board of Education declared in 1954 that separate conditions are inherently unequal, our nation's laws have moved from using explicit racial categories in an oppressive manner toward using these explicit categories to ameliorate race discrimination in society. And then as we moved into the end of the 20th century and the beginning of the 21st century, we found that claims of reverse discrimination and new interpretations of the 14th Amendment in regard to affirmative action caused the court to reestablish a way in which it would no longer make explicit race categories a way to remedy racial discrimination. And thus, the courts are now prohibiting the use of race in many instances, even when it is in the effort to remedy previous racial discrimination. Nevertheless, the prerequisite cases are relevant to an exploration of the contemporary relationship between race and law. Finally, Lopez says, these cases evince many different facets of the legal construction of race, Consequently, their study will be helpful in developing an understanding of the more subtle constitutive processes at play. And we will move forward from this to talk about our chapters that will include Korematsu, Hirabayashi, and Ex parte Indo, and then, of course, later on, Hispanics and Latinos. But we will not need to record those lectures.